Yes.
Hello. Good morning to one and all for the webinar.
Shall we start?
Greetings from G.S.Pillay Engineering
We can start.
College, Autonomous, Nagapattinam. Department of Civil Engineering is organized industrial webinar on contract law today. So I welcome you all to the webinar. Our HOD, Honorable Dr. R. Sivakumar sir is going to present a welcome address today. Sir, you can proceed, sir.
Yes, thank you, madam. Thank you, madam. Very pleasant. Good morning, one and all, attending this webinar. I hope everyone be safe against COVID-19, and I pray God for your safe and secure. On behalf of our G.S.Pillay Engineering College and the Department of Civil Engineering, I warm welcome our special resource person of today's webinar, Mr. N.S.Srinivasan sir. He is a Deputy General Manager, Contracts and Claim Management, L&D, Chennai. Welcome you, sir. Welcome.
Thank you. Good morning.
I welcome our beloved CEO, sir, who is the important person for giving full support for arranging this type of wonderful webinar. I welcome our CEO, sir. And I welcome faculties and students of various colleges and various disciplines. And I welcome heartily the faculties and students of G.S.Pillay Engineering College from all disciplines. Welcome you all. Today's session about the contract law, a wonderful area which is useful for not only civil engineering, but also all the domain personality who interacted with all kinds of business. I would like to say a few words about Mr. V.S. Srinivasan sir. He has completed his BE from Madurai Kamarajar University in the year 1994 with the gold medal, and a diploma in construction management from Annamalai University in the year 1997. And he did his Master of Business Administration from Annamalai University in the year 2010. And he is an associate member, Institute of Engineers, India, AutoCAD, Primavera, StatPro are some software proficiency of his efficient. He knows Tamil, English, Hindi, and Telugu, 4 languages. What so great. Some of his training programs are L&T, LDA, Lonavala, Legal Systems and Commercial Laws from NLS, Bengaluru, Indian Institute of Management, Ahmedabad, Legal Aspects of Contracts, and the Princeton Academy, Mumbai, the HRS, National Highways, Chennai, and NITI, Computer Aided Design Applications, Noida. Hence, I request our special resource person, Mr. N.S.Srinivasan sir, to share his thoughts and ideas about contract law. Thank you, sir. Sir, please go ahead your own way, sir. Thank you. Thank you very much.
Yes, sir. Good morning, friends. Hope you are all safe in your places during this COVID situation. This is only temporary and it will reverse soon. So be safe, save and secure your family. So this presentation I have categorized into 3 different sections. Initially, I will give you the background. Then there will be question and explanations. Then question and answers. So I am toggling between the presentation and the face-to-face because I have lesser number of sheets. So I am sharing my screen.
It is visible, sir.
Yeah. So before going to proceed further, I want to understand how many participants are actively present. So there is a link given here, URL, Uniform Resource Locator. You can type in your mobile and I'm also typing. So it will give you a question. In which capacity you are attending this session? So 3 options are given. I am typing it others, and put your vote here, and you can see live votes coming in. The link is given in the top. I think all the participants use this link in your mobile web browser. Type the URL etc.ch/x and submit your responses. I think 42 persons are alive.
Yes, sir. Till now, 42 participants are live out of 183 registered.
Yeah, but no one is participating. That's why I wanted. So they have to type the URL in the mobile browser, so that, because in the Q&A session, I'm going to ask 3 questions, which is very minor in nature, which is very basic. And don't worry if you don't know the answer also, I'm going to explain. I request participants to type the URL in your mobile browser and submit your responses. It will help you in doing the other 3 questions. Yeah, it is increasing now. I think we can proceed because the people are coming in slow. So let them do it later. So the URL is etc.ch /x capital H du. So the background is nothing but there are 2 common laws in the entire world. So we have 195 countries in the world. The 2 common laws is civil law as well as common law. So civil law is nothing but it is a written law codes, wherein the court decides based on the written law. So there won't be any change in that. The countries following the civil law is China, Japan, Germany, Spain, and France. whereas the common law countries are UK, USA, Australia, and India. It has come from UK basically. Common law is nothing but it is unwritten law, and the judiciary precedents and case laws being followed by the Supreme Court to interpret the law. So Supreme Court is the custodian of the law of the country in India. So there are other laws like Muslim law, customary law, and mixed law. Mixed law is combination of 2-3 laws. So that is mixed law. So in India, though the written constitution is available, we follow the judiciary precedents and case laws. That's why we are into common law country. And the Constitution of India is written in November 1949, and it has come into force from 26 January 1950. There are 32 parts in the Constitution of India, mainly fundamental rights, definition of state, union territory, judiciary system, etc. And the president shall preserve, protect, and defend the constitution through 3 branches like legislature, executive, and judiciary. Legislature will enact the law, and executive will implement the law. Executive in the sense state and central government, and judiciary will interpret the law. The Supreme Court of India is the custodian and guardian of the constitution, who interpret the constitution and derive the law. Under 32 parts, part number 13 is related to trade and commerce, which is nothing but the business. And in the business law, we are into so many laws, including the contract law. There are tax laws, company law, partnership law, property law, and contract law. In contract law, the Indian Contract Act 1972 is the major act which follows in the contract law. And in case of disputes, we will use the Arbitration and Cancellation Act 1996, which is amended in 2015 recently, and it is also second time amended in 2019. The major difference between 2015 and 2019 is in 2015, the short-term procedures have been adopted. For example, fast-track arbitration has been introduced, which is 6 months. It will go extend up to another 6 months. So you can get the dispute resolved within 12 months. And the amendment 2019 is majorly on institutional arbitration. And my dear friends, you have to understand the law. You have to have the knowledge and wisdom of the law. Ignorance of law is not an excuse. So everyone should know the law. So if you compare what is wisdom and knowledge, I will explain you. You might be aware of 5 W and 1 H. What, when, where, who, why, and how. So what, when, where, who will give you data, and if you put in terms of a context, it becomes information. If you organize to create a meaning, it becomes knowledge. If you analyze through a methodology how it has been done, it is showing the intelligence. If you apply sense why this has happened, then it calls wisdom. So this is the major difference between wisdom and knowledge, and you should know the law, and ignorance of law is not an excuse. You can also know no third party can sue a party into a contract. So it is called doctrine of privity. So law does not allow a stranger to file a suit on the contract. The right is available only to the person who is a party to the contract. So there is a difference between suit and writ. Suit means the self who is a victim can file a suit, whereas the difference between writ and suit is writ anyone can file a petition. It should be a common issue wherein the other party also file a writ petition. Courts are generally applying the principles of natural justice, contra preferentum, quantum merit, and estoppel. The principles of natural justice has two things. There should not be any bias. The same party cannot be judged to his own case, and the other party should be heard properly so that the judgment will be given a common ground. So let us move on to the question number 1. I am going to share you the screen. So you can go to your mobile and answer the question. The question is alleged contract contingent upon event? I will explain what is alleged contract at a later point in time. So before going to the explanation of alleged contract, we have to know the background of the contract. So let us wait for some more time. The participants are submitting their answers. There are only 5 voters have submitted their answers. I think there are many participants in this webinar. I don't know why they are not submitting. The link is given above, etc.ch/H_HDU. This webinar should be somewhat interacting. That's why I added this polling option. It should not be like one-sided, so that I can speak on and people are not interacting. So okay, I think let us proceed. So the answer is yes. So the background of contract, I will tell you. The contract is an agreement enforceable by law. All contracts are agreements, whereas all agreements are not contracts. There are 10 basic elements which need to be fulfilled so that the agreements will become a contract. First one is agreement, that is meeting of minds, consensus ad item. So both the parties should have a common goal to do something or not to do something. Then only it becomes a contract. Similarly, there should be some intention to create legal relationship. That means you cannot sue a friend who has not come for a party, because that is social contract. It can't be legally enforceable. Whereas in a agreement where both the parties have to do certain responsibilities, then the party who is not doing the their obligation, the other party can go to court. That is called legal relationship. There should be the intention to create legal relationship so that the agreement become contract, and there should be free and genuine consent. There should not be any coercion, there should not be any force, undue influence, or misrepresentation. If all these three are there, or three or four are there, then it is a void agreement, it cannot be enforced. Similarly, the parties are competent to contract. That means there should be, you cannot contract with a minor, so it should be major. Similarly, he should not be a leniency or idiocy. Idiocy means mutal, leniency is pythium. I can use Tamil language also so that people can easily understand. So the party to the contract should be competent, and it should be a lawful consideration. That means you cannot sign a contract for any smuggling of goods. It is illegal in our country. So the object of the contract should be lawful, and the agreements should not be declared as void by any court so that it it becomes binding and it becomes contract. And there should be certainty of meaning. That means the contract scope of work, the obligations should be defined properly. You cannot say a vague term so that the other party cannot understand. So it should be with meaning, and it should be in with an elaboration that the other party can easily understand what is his obligation, what the other party's obligation, and it should be the possibility of performance. While signing an agreement, it cannot uh, termed as non-existence. So there should be a possibility of performance. And in case of a death of a person, it cannot be performed. Similarly, in case of bankruptcy, then also the contract cannot be performed. And finally, there should be a legal formalities to be fulfilled, like signing of all the pages in a contract as well as stamping of a contract. If any pages are not signed or stamping is not done, then it becomes invalid. That is called error in the contract. So it can be rectified at any point of time, but the other issues cannot be rectified. So all these are essential elements to become a agreement become contract. Then there are many types of contracts in terms of enforceability, mode of formation, and according to performance and mode of payment. So I think you might be aware of all these things, but however, I am going to touch upon only an important things which are basically helpful in your professional and personal life. The contract is a very vast syllabus. The important points only are dealt here. Valid contracts is that all the 10 elements are fulfilled, then it becomes valid. And if the voidable contracts is nothing but the other party, if he is not able to perform because of the default of the first party, then it becomes voidable at the option of the second party. So he can continue with the contract, or he can resign the contract. Resign means he can close the contract. It is at the option of the other party who has been affected by the default of the first party, the obligations which are not met. And void contracts are nothing but the essential elements. If anything is missing, that becomes void contract, which we have already discussed. Illegal agreements, again, that smuggling or killing a person, which is illegal under law. So you cannot have an agreement to kill a person. It cannot be enforceable because it is void and illegal. Similarly, unenforceable agreements. These are all in the point of view of enforceability. When it comes to mode of formation, express contract, implied contract, and quasi contract. Express contract is written contract. So all the obligations are expressed in the contract itself. Whereas the implied contract, there won't be any contract, but the obligations are implied, and still the obligations are performed and the work is done. For example, if you enter into a bus by purchasing a ticket and sat on the seat, the obligation of you is done, and the other party, who is the bus driver and conductor, has to let you down at your destination. That is their obligation. So though there is no contract exists, but it becomes a contract because it is an implied contract. Similarly, quasi contracts is nothing but it is forced upon by a statute, that is statutory body. For example, if you see a person is helping to a minor or a widow without uh, saying that it is free, then the other party, that is the minor or the widow, has to pay to the person who has helped from their property or whatever they have at their disposal. So the quasi contracts are not a form of agreement, but still it is there. The difference between implied and quasi contract is nothing but the act will become a contract in terms of quasi contract, whereas the contract will give you the act in the implied contract. So let us proceed with the other types of contracts. In accordance with performance, it is executed, executory, unilateral, and bilateral. Executed means the completed contracts or projects. Executory means which is ongoing contracts. Unilateral is nothing but it is one-sided, like one-way wall. It is, I can quote some examples of like a notice given for a reward in case of finding out any missed object. So it is one-sided and it is open to everyone. Any person who found that missing object will get the reward. Then that contract got executed. So it is unilateral. And bilateral is like purchase of any goods. So both the parties, one party is giving money, the other party giving goods. That is called bilateral. So, and when it comes to mode of payment, there are many uh, uh, sections like lump sum contract, unit price contract. Unit price contract is nothing but BOQ contract, bill of quantities. So whatever quantity is executed, it is paid based on the rate quoted by the contractor. So cost plus contract, incentive contract, percentage contract, these are all other mode of payments, and it comes under different types of contract under mode of payment. There are other contracts which you like to know, which is nothing but unconsignable contract, adhesion contract, and finally aleatory contract. So unconsignable contract is a dominance, and it is like exploitation of the superiority on a particular thing. For example, an uneducated person going to a mobile shop and getting the mobile of 5,000 with a price of 8,000. So it is something like exploitation or cheating by the shop owner, and it becomes unconsignable contract, and it is not reasonable because he has not taken the reasonable price of the mobile. Instead of 5,000, he took 8,000. So the person who purchased with 8,000, if he knows that he was cheated, he can go to the court and sue the shop owner, and the court will rescind the contract, and they will ask the shop owner to pay the price through penalty, or it goes up to imprisonment. Whereas in adhesion contract, it is also like superiority. I can quote some examples like purchasing a SIM. So when you purchase a SIM, there will be certain terms and conditions at the back of the application, which is in very small fonts. You cannot even read. So there is no option to you. You have to either get it or leave it, such kind of thing. So you have to sign the application and get the SIM. Otherwise, you will not get the SIM. This also sometimes become unenforceable because not all additional contracts are unenforceable, because all the terms and conditions may not be illegal or unenforceable, because it may not affect the persons also. In one or two cases, it may affect a single person who can go and shoot that particular service provider, or if it affects to the entire society, then it becomes unenforceable and the court will not accept that adhesion contract. When it comes to aleatory contract, which is normally used in insurance policies, for example, it is like allocation of risk. In case of fire or something like that, you are going to allocate the risk by taking an insurance. So you have to get a fire policy wherein the premium is paid, but the event may or may not occur. If the event occurs, then only the insurance company has to pay the sum assured. Otherwise, he will enjoy the premium because the incident has not happened. So it is contingent upon whether the incident happens or not happens. So that is called aleatory contract, which was the question given to you. So let us move on to the question number 2. Go to your mobile and see the second question. So whether business law and corporate law are one and same. Please submit your answers. Dear friends, please answer the question. If you don't know, also nothing to worry. I am going to explain you. But please submit. It should be interactive. The question is whether business law and corporate law are one and same. If it is yes, no, or not sure, the options are given. Please submit.
Please, all the participants are requested to interact with the resource persons. That's only very useful and helpful. All the participants are requested to submit your answers, whether it is yes or no, whether it is right or not. You must please interact with him.
Let me see how many participants are there. 49 live. Okay. So 49 participants are live, but they are not interested to answer this question. I don't know why. Okay, I think let us proceed. Let us not wait for them to answer. The answer is no. Both are different. I will explain what is business law and what is corporate law. Business law or commercial law, it is earlier called as mercantile law or trade law, deals with the sale and distribution of goods. The performance of obligations of the parties are listed, and it comprises of contract law, which we are dealing with, consumer protection law, intellectual property law, tax law, partnership law, etc. So when it comes to corporate law, which is a skeleton, or you can say a structure, it is at the structure level to form a company or operate the corporations. And it also talks about the shareholders' rights and obligations, who has formed the company, owned the company, or operate the company, or manage the company. So it also talks about mergers and acquisitions, etc. It is at the skeleton level, or we can say at the outer level, whereas the business law is the overall, and it is it has many laws within the business law, and the corporate law comes under skeleton level and the outer level. And when it comes to contract law, which we are going to deal with, as I already told you, Indian Contract Act is the primary law under contract law. And earlier, there were sections of Sales of Goods Act and Partnership Act in the Indian Contract Act, which later on removed from the Indian Contract Act, and it has become a separate act, like Sales of Goods Act in 1930 and Partnership Act in 1932. And under contract law, I already told you about the Arbitration and Cancellation Act 1996. And in the contract law, there are general conditions which are formed by the FIDIC. The FIDIC contract are generally used in World Bank and Asian Development Bank projects, wherein it is mandatory to adopt the FIDIC conditions. FIDIC conditions are popular in many countries, whereas the other form of conditions formed by NEC, that is New Engineering Contract, which is basically used at UK, Hong Kong, South Africa, New Zealand, and Australia, which is not popular in India because it is not favorable to the contractor. It is favorable to both. It has the collaborative approach, and it is having the flexibility, clarity, and simplicity for both the parties. Whereas the FIDIC will be favorable to the contractor. So, and the one more point here is why it is not popular in India, because in India, under Indian Contract Act, there is no limitation for your right to exercise. For example, in FIDIC, if you don't raise the right within 28 days, then you will lose the opportunity to get that money. For example, uh, if you incurred additional expenses in your contract and you have not informed within 28 days, then you lose your right to claim that money. Whereas in Indian Contract Act, there is no such limitation, and it goes by Limitation Act. Limitation Act tells about 3 years time period for us to raise the issue under dispute resolution or arbitration or under court. So the 3 year period, which is contradicting to the 28 days given in FIDIC, because of which in Indian contracts, FIDIC conditions are not finding place. Indian contracts in the sense government contracts. Whereas from private to private contracts, they are not worried about this, and they are going by this FIDIC contract because it is favorable to the contractor. So we have model construction agreement in road contracts. Our company is doing road business, road infrastructure business, and we have BOT projects. BOT is nothing but build, operate, and transfer. HAM project, hybrid annuity model, and annuity model. Here we follow model construction agreement, which is derived by the BK Chaturvedi committee, and it is being used. We have standards and specifications, manuals, IRC codes and IS codes, and international codes for doing a particular work. We have to adopt those codes and implement the project. We have also called pre-award and post-award contract management under this contract management. The pre-award contract management is nothing but before signing or executing a contract, what are all the process involved will pre-award contract management, which is also called contract administration, whereas the post-award contract management is after signing the contract, how to implement the contract, what are all the obligations by both the parties, and what are all the risks involved, and how to rectify those risks, and how to correct, take corrective and preventive actions so that it cannot be it cannot reoccur once again. So to ensure that the post-award contract management is also there, and in very large companies or organizations, there will be two different entities or parties who will taking care of the contract administration and contract management separately. The contract administration will also come during the course of project, because in case the contractor has not completed the project and in between he goes away, then we have to find the new contractor to do the rest of the job. Again, that contract administration comes in and they have to find their new contractor, and the new agreement will be signed to execute the remaining part of the project. So the contract administration also falls under contract management. So like what we discussed, the business law and corporate law, here also the contract administration is like pre-award contract, and contract management is post-award contract, and entire thing is also called contract management. In smaller companies, both there won't be any separate persons. Both will be tackled by a single person who is contract manager, who will do pre and post both. So it is always better to deploy the same person who has done the pre-award contract management, because he will be familiar with the project and what are all the risks he has foreseen during the time of bidding. He will ensure that that won't be uh, uh, creating any problem during the execution. So it is always better to have the same person while doing the contract. And this is the diagram where you can compare what is contract administration and what is contract management. So as I earlier told, contract administrator will also come under or during the execution of the work in case of any problem in executing the work, or in case of any replacement of the contractor. It is not only the fixing of contractor, he has to also see what are all the compliances and statutory requirements to do in the project during the execution also. So he will also monitor the financial progress. So this are all comes under contract administration, and in contract management, all including you have to write down the timelines, what are all the obligations, and what are all the risks involved, and you have to intimate then and there so that your right is protected. So here the documentation is very much important. We need to record everything at the appropriate time so that you can get back and claim at a later point in time to get the money which you have incurred additionally. So let us move on to the third question. Go
Hello,
to
sir.
yeah.
Hello, sir.
Yes.
சார் அந்த லிங்க் வந்து கொஞ்சம் சாட் பாக்ஸ்ல போஸ்ட் பண்ணீங்கன்னா மேபி இட் வில் பி யூஸ்ஃபுல் சார். அவங்களுக்கு ஈஸியா ஓபன் பண்றதுக்கு ஈஸியா இருக்கும்னு நினைக்கிறேன்.
It is there in this, no? Yeah. The link is shown here now.
அது அது நம்ம சாட் பாக்ஸ்ல போட முடியுமா சார் அந்த லிங்க் டைரக்டா?
I can't do, madam. You can do it from your
Okay,
end.
sir. I will try, sir. Okay, thank you, sir.
Yeah. So the question is whether cancellation is an alternate dispute resolution. Yeah, it will be visible in your mobile. So please answer the question. So you will see the live submissions. Fifty-seven participants are there, but no one is submitting the answers. So the link is etc.ch/XHDU. While submitting the answers, I will give you certain tips how to do contract management. So there are ISO procedure like PDCA, plan, do, check, and action. So you have to plan it and do it, and you have to check whether you are on the right path or wrong path. Then you have to do action. So that is called PDCA. And you have a tip for time management. So you have to list down all the pending issues or pending works in a manner that what are all the urgent issues or tasks to be done and what are all important tasks to be done. So if it is urgent and important, you have to tackle it first. And the second priority is important but not urgent. So if you focus on second priority so that it won't become your urgent and important, as an SOS you have to tackle those things. If you don't focus on the second priority, it becomes your first priority. And which is important but not urgent, that is your second priority you have to tackle. If it is urgent but not important, you can delegate it to somebody else. And if it is not urgent and not important, then you can leave it or ignore it. So these are the different type of urgency or priorities of your tasks to be done, so that you can easily manage your time. And while during contract management, we have excusable and compensable. There are two things: excusable, non-excusable, and compensable, non-compensable. So if it is excusable, you will get extension of time, and it is compensable, then you will get the money which you have incurred additionally. Whereas if it is non-excusable, you will not get extension, and if it is non-compensable, you will not get any compensation. So you have to bear it, because it is, if the project is delayed because of you, that means if you are under contractor side, then you will not get extension. You have to bear whatever expenses you have incurred. In the other case, if the delay is because of the other party or who is the employer, then he has to give extension and compensation as well. I think let us proceed to the answer. So most of the participants have answered correctly. So yes, mediation is an alternate dispute resolution. We have four kinds of alternate dispute resolution. One is starting with negotiation. So here both the parties have to sit together and discuss the issues and negotiate and conclude. So if it is not done, then a mediator is required, which is the second option, wherein the mediator will be present and see the process, how they are dealing or discussing with the issues. But the mediator cannot give any solution. He will only organize the meeting and see that it is going smoothly. And if the parties have discussed and settled the issue, then it closes there itself. If it is not closed, then it goes to conciliation, that is third process, wherein there will be one conciliator or three conciliator. It all depends on the magnitude of the issue, and the conciliator will discuss with the parties separately as well as combinedly. And while discussing separately, he will give the solution, and he will also give the reasoning why he is at fault or he is not at fault, and how the courts are going to deal this issue if they go to court. So he will give the solution as well, individually as well as combinedly, and try to settle the issue to for an amicable settlement. Then it becomes, if the issue is settled at that level, then it is closed. If it is not settled at even at conciliation, for example, if the conciliation has failed, then it goes to arbitration. Arbitration, again similar to conciliation, there will be arbitrators, one fixed by the one party and the other one fixed by the other party, and both the arbitrators will finalize the third and presiding arbitrator. And in some of the cases, sole arbitrator also there, wherein only one arbitrator will decide the matter. And in normal cases, three arbitrators will be there. And similarly, the arguments are put forth before the arbitrator. There will be submissions of claims as well as rejoinders and reply to the rejoinders. And finally, it will be decided by the arbitrators, and the award will be pronounced within the timelines given. So all these four comes under alternate dispute resolution, and there is a difference between arbitration and litigation. So arbitration is very cost effective and uh, speedy resolution, whereas litigation will take its own time. And if the party goes to court, then if the order is given, the other party has to accept, or he will again appeal in the higher courts, and finally it ends up at Supreme Court. So the legal process will take much more time, and it is costlier also. So normally people will try to close it through arbitration, and there is a clause in the contract to be provided as an arbitration clause. If it is not there also, the parties can decide themselves and put a supplementary agreement to that effect, and have a arbitration clause even after executing the contract. So it all depends on the parties who are dealing with the dispute. So the instead of going to litigation, it is always better to resolve through arbitration. First of all, important thing is that if you foresee all the risks and put it in paper in terms and conditions in the agreement, and those disputes are foreseen, and the contract is drafted in such a way that what are all the remedies can be given during the execution of contract, then there won't be any dispute, and the project will be completed very smoothly. So some examples I can tell you. For example, later in 2017, we have GST clause, that is implemented by the central government GST. So if the contract doesn't have the change in law condition, then it will be very difficult to get that impact of GST. So you should have the change in law clause in your contract. Similarly, there should be a force majeure clause in your contract, so that any unforeseen activities can be tackled, and the remedies should be given in the contract itself how to tackle those unforeseen conditions. Force majeure is nothing but like act of God, flood, cyclone, something like that. And recently we are facing the COVID situation also, which will comes under force majeure. So these two clauses are very important, and it should also be kept in mind that the language of the contract should be very simple and easily understandable. There should not be any interpretation of clauses, and then there will be no dispute, and the project or the assignment will be completed very smoothly. I think I have come to a closure. We have understood about what is contract law, and we have also dealt with alternate dispute resolution, and what are all the types of contracts, and what is aliterary contract, unconsignable contract, adhesion contract, types of contract, everything. So I think I can close this now, and if there are any questions, we can do question and answers. Madam, is there any questions?
Till now there is no questions, sir, because the time is 12:30, so that they are not posting. So 1 minute, sir.
Participant, if you have any questions, please put it on so that I can answer.
So, sir, I have one question.
Yeah, madam.
If in contracts, there is a, for example, if 5 lakhs amount means how much we have to, who is eligible for taking those contracts in government side? If it is 5 crore means who is eligible? That eligibility comes in what way?
Is it government contracts or private contracts?
You can tell both, sir.
So in government contracts, there will be certain limits prescribed so that the contractors who are satisfying those limits, they will register themselves, and those alone can participate in the tender.
Okay.
Whereas in private contracts, there is no such limits. It all depends on the work and the owner of the work, how he want to be executed. For example, it is very sophisticated and a very important thing. He can choose to a particular agent and a particular contractor and directly give it to him. So it all depends on the. In case of private, there is no such bar, and you can do whatever you want. Whereas in government contracts, it is prescribed, so they have to follow the procedure.
Procedures.
Yeah.
Suppose a student is graduated from currently means, is it eligible for taking a contract, or he needs some experience?
He can register himself as a contractor, and he can take up the lesser quantum of works initially. And if he proves and he got some completion certificates, he can quote for the bigger projects and go on.
Okay. Yes, sir.
It's 12 o'clock.
So there is no questions in the chat box. Okay, sir. With that, we wind up, sir.
Yeah, thank you very much, madam. Thank you for giving me the opportunity.
1 minute. 1 minute. HOD, sir?
Yes, madam.
Shall we wind up, or you have any queries? You can ask sir.
No, madam. If there is any queries or doubts from participants, you may take up the last session.
Okay, sir.
Malika ma'am,
சொல்லுங்க.
chat boxல students ஒரு 4 questions கேட்டிருக்கானுங்க மேம்.
எங்க இருக்கு? ஃப்ரண்ட்ல இருக்கா? இங்க இருக்கு.
First question ஹரிஹரன் டி கேட்டிருக்கான் பாருங்க.
அப்படி சொல்லுங்க சாருக்கு.
Sir?
Yeah.
One student asking a question, sir. In general, holding the work is acceptable in the event of non-payment. அப்படின்னு கேட்டிருக்காங்க சார்.
Holding the work in case of non-payment. Actually, in a contract, you are signing the contract saying that you will complete the project. So that means you should have the capability to execute the work, and you should have your own resources. Resources in the sense manpower, money, and machinery. So you can't say that because of money I am going to stop the work. You should have planned it ahead, and you should have the resources including money to do the work. If you stop the work, then the project will suffer and the owner will not pay. If he is not paying now, if you stop the work, he will definitely will not pay at any cost. So it will hamper you only. So you have to complete the work and fight for your right at a later date. If you stop the work, then the relationship will go away and you will not get new projects from the same person. So it is always better to resolve the issues amicably, sit along with him, discuss with him, and go to a common ground and resolve the issue and complete the project. Stopping the project will not help at any cost.
Okay. So one more question now appears, sir, from Asat. How the contract can be managed in the pandemic time situation? The material cost may high and time can be in end line. How was it manageable?
Yeah, in COVID situation, it will come under force majeure, and it all depends on the if it is government, the authority has to finalize and how it has impacted the project, and they have to compensate in both ways. One is extension of time as well as compensation on the additional expenses, like what he said, the cost escalation, as well as in any other impact on the project. So in private thing, it has to be decided by the owner, and he has to compensate in both extension as well as compensation. So this COVID situation has both the components. In some cases, they will only give extension, they will not allow compensation. In some cases, they will allow both. It all depends on how it has impacted that particular contractor or whoever it is.
One more question, sir. D. Hariharan is asking, suppose client is not paying the money in this situation, how can I ask, in what way I'm asking to them?
Client is not paying means client also got affected, no? So you have to, so that's why extension of time will be definitely given by whoever may be the client. And you have to start the work after receiving into that, after getting favorable situation, after closure of COVID situation, then you can start the work and complete the work and get your money. So till that time, nobody will sue you, because it is like impossible act during the COVID time. No one can sue you, so they will definitely give extension, and you can do the work later on.
Okay, sir. Okay, thank you, sir. Thank you, sir. Now the time is for vote of thanks. HOD, sir.
Ma'am, yes, ma'am, you proceed. No problem.
Okay, sir. It gives me an immense pleasure in presenting vote of thanks. First of all, I would like to thank our beloved Secretary, sir, of G.S.Pillay Engineering College, respected trust members, Honorable CEO Chandrasekhar sir, eminent Principal Dr. Ramabalan sir, our HOD Dr. R. Sivakumar sir, for encouraging us to organize this webinar on contract law. Today's session was very informative, interesting, and innovating. Lot of response from various participants. This session is useful to the students and faculty members also. I extend my profound thanks to Mr.N.S.Srinivasan sir, Deputy General Manager, Contracts and Claims Management, L&T, IDPL, Chennai. He explained clearly as arbitration, negotiation, conciliation, mediation. So all these things, a type of contract laws, he explained. He answered very patiently to the questions those asked in the chat box. I would like to extend my heartfelt thanks to our department, colleagues, students. Once again, thanks to all participants for attending this program. Thanks to God, whose blessings only we carried out this program successfully. Stay safe, stay healthy. Thank you, sir. Once again, thank you, sir.
Ma'am,
Thank you, madam.
feedback link, ma'am.
Okay, sir.
So, dear participant, give your honest feedback so that I can improve better.
Okay, sir.
Yeah, thank you very much.
Sir, thank you, sir. Srinivasan, sir.
Yeah, thank you.
And thank you for your wonderful support, sir.
Yeah, thank you very much.
Thank you very much, sir.
So, let us close it, no?
1 minute.
Yes. 1 minute, sir.
Madam, let us close.
Feedback link
Sir.
போட்டிருக்கேன் சார் ஒரு 5 minutes
Oh,
இருக்கட்டும்.
okay, thank you.
Srinivasan, sir.
Yeah.
My camera off பண்ணீங்க, sir.
Okay, sir. Thank you.
Okay, sir. Thank you, sir. Thank you.
பிரகாசம் சார்
சொல்லுங்க, ma'am.
லிங்க் வந்திருக்கு பாத்துக்கங்க.
Okay, ma'am. Okay, ma'am. Done, ma'am.
கரெக்டா இருக்க பாத்துக்கோ.
Okay, ma'am. Done, ma'am.
ஒரு 5 minutes இருக்கட்டுமா?
ஆமா, ma'am. 5 minutes கழிச்சு wind up பண்ணிக்கலாம், ma'am.
லிங்க் எல்லாரும் போடுவாங்க.
Okay, ma'am. Okay.
Shall we close, sir? Prakasam, sir?
Ma'am, wait a minute, ma'am. Exactly 12:10, ma'am.
Okay, sir. Okay, sir.
Okay, ma'am. Thank you, ma'am. Srinivasan, sir.
Yes, sir.
Please share any feedback from this webinar, sir.
Yeah, definitely.
Ma'am?
Okay, sir.
Okay.
Shall I stop, sir?
Yes, ma'am.
Okay, thank you, sir.
Okay, thank you.